CCS 101.1 FM and AM 1160. Marshall Chriswell with us once more. This radio program intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. A guy like, for instance, Marshall Chriswell, who's on the line with us this morning. Marshall, good morning.
Good morning. How you doing?
Wonderful. Good to have you with us again. All right, so let's talk about this. We talk about estate law a lot in these segments, and the need to have your estate plan all up to date. Just to have one in the first place. Many people don't. So people need to get to work on that. But what about the person on the other end of it? What about the person who will be the recipient or the beneficiary of an estate plan? Are there things that those folks need to be aware of and maybe even doing ahead of time?
Yeah, absolutely. And you're right. We haven't really talked about estates from the perspective of the beneficiary of the estate. And the estate or trust, whatever the vehicle is that we're distributing assets after someone passes away. If you are the beneficiary, a named beneficiary in that document, or you think you might be, there are absolutely things that you should be expecting and things that you should be doing.
Okay.
First off, when someone passes away, and I think we've said this before, it's not like in the movies where the people that are named in the will and the family members all gather together in a wood-paneled room with leather-bound furniture and have the official reading of the will, and it's stated publicly what's in the will, and everybody's aware of it. That just doesn't happen, and I don't know if it ever happened. But
it should.
It should, but it doesn't. And so, there are times when someone passes. You got family member or parent who passes away, and you're kind of left in the dark. You think, well, I think I'm probably in the will, but I don't know whether I am or not. And there are things that you need to do. You have to know that the executor or the trustee of the will is required to administer the estate, assuming there are assets, to administer the estate. If it's a will, that means admitting the document to probate in the Register of Wills in the county where the person resided, or as a trust to formally take control of the trust assets. And when those things happen, the law says that the executor or the trustee has got to give notice to the beneficiaries under the relevant provisions of the Orphans Court rules. So within 30 days of beginning administration, they need to send out notice. And as an attorney for estates and trusts, I generally will include a copy of the controlling document, whether that's a will or trust. Generally provide that to the beneficiaries. Not everybody does that, but you have the right as a beneficiary to receive it. So the first thing to know is, within 30 days of the administration beginning, which is different from the date the person passes away, you should be receiving notice. If that doesn't happen, you need to be reaching out, whether it's you personally or through counsel, to the person you believe is the executor, the person in control of these assets, the trustee, to see, okay, am I named in this document, and what are the provisions? Mm-hmm. And so that communication, number one, is key. I have clients that come in and they've kind of sat on their hands for 6 months, and they say, well, I didn't know I was allowed to do anything, or I was supposed to do anything. You absolutely have the right to reach out, and the person administering the estate or trust has an obligation to give you information. So that's important. And then let's say I've had situations where there are assets, estate assets. Person dies and they have a house, they've got bank accounts, they've got, there are assets, and the person that they've named as the executor just isn't doing anything. Just for whatever reason. Sometimes it's legitimate reasons of being grief-stricken or being overwhelmed, not knowing what to do. The person who's named as the executor doesn't do anything. You've got to know that you have the ability to, if they refuse to take up the duty that they're supposed to do, you can go to court and you can compel the estate administration. And you can actually ask the court to have them removed as executor if there's no good reason that they've delayed matters.
Mm-hmm. Are there penalties that person would then have to be subject to?
So anytime a fiduciary, an executor, a trustee, even a power of attorney, mishandles an estate or mishandles the property that they're to be administering, there can be penalties, particularly if their delay or their neglect has caused a financial loss, right? Mm-hmm. Because a big part of your job when you're in a position where you're handling assets and funds of someone else, you've got to preserve those assets. And if the person passes away and they've got a house or personal property that needs to be physically preserved, and the house sits vacant for 5 years, like I've seen, and there is a depreciation, dissipation of these assets, then absolutely that person can be held responsible.
If somebody is the beneficiary and is anticipating that they'll get some sort of monetary compensation from somebody's estate plan, there probably are some things that person should be doing ahead of time as well to set themselves up to receive it, and from a tax standpoint, correct?
Well, from a tax standpoint, generally when you are inheriting money if this is a state in Pennsylvania, the number one tax implication that there is Pennsylvania inheritance tax. And how that tax is paid depends on the language in the document, the will or the trust. Sometimes the taxes, the inheritance taxes, are paid out of the estate assets, so you don't have to worry about paying those directly. But they're paid out before you get the funds. Mm-hmm. Sometimes, depending on those provisions in the document, the beneficiaries are responsible for paying their pro rata share. And also there can be assets that pass outside of the will, such as retirement accounts or annuities or things that have beneficiary designations on them, CDs and bank accounts that are jointly owned or that are held in trust for you as a beneficiary. You're going to be responsible for paying inheritance taxes on those. Also, retirement accounts such as IRAs that are transferred to you as a result of someone passing. Well, you've got to be real careful and work with an attorney, an accountant, and a financial advisor to make sure that when those funds are distributed to you, you're selecting the option for distribution that is most beneficial to you. You have, particularly with an IRA, you can take the money outright, but you've got to pay income taxes all on it in that year, right? If you can have the money rolled over into a retirement account for yourself, and generally, with some limited exceptions, you can withdraw those funds over a 10-year period and break up the income tax hit on that. But once you've put the money into that retirement account, you can't, you may incur penalties if you depending on when you pull it out. So you've got to be careful and consult with professionals.
Yeah, and obviously an attorney is going to be your first place to start when you're thinking about as the recipient of anything, and especially an estate plan. Are there other considerations for people who would be recipients of somebody's estate? Number one, another thing is, you should have some patience. I said sometimes people sit on their hands. I get
clients that come in that are beneficiaries of estates, and we'll talk about it, and maybe I'll represent them as the beneficiary. I'll always reach out first to the executor, the trustee, or their attorney if they have one, and just get a little bit of an update as to what's going on, and maybe communicate, hey, there are these items of personal property that my client would like to have. Maybe my client was a child of the decedent, and there are sentimental items that they'd like to get, and we communicate about that. But you also have to understand that estate administration is not a fast process. Even the simplest of estates are going to take 6 to 12 months to resolve. So, you want to be a little bit patient with respect to getting a final distribution from the estate. But on the other hand, if there is a delay in the process, you can we can always file a petition to require the executor to file a formal account if they're not communicating with us or whatever. So you want to have some patience and let them do their job, and I know that just from being on the other side of it. But if it appears that they're not doing what they're supposed to do, then take action, because what you don't want to happen is the funds to be gone, whether they've been misappropriated or assets neglected and things like that.
Yeah. As we talk with you, and we do these segments quite a bit, one of the things that always impresses me is the idea that we should have a relationship with our attorney before we actually require that attorney to act on our behalf. And it's always good to have somebody that you've already have lined up that is going to be your advocate, so that when something occurs, it's not the beginning of a brand new relationship. You're not starting from the very beginning, and you know each other, and you know what each other's issues are, and I'm sure that you would appreciate that as well. I
do, and I really I do operate my practice that way, as far as I want to get to know people. I want people to feel comfortable. If you have an issue that you think that's a legal issue, or you think is a legal issue, that they can give me a call. And there's so much in this world with respect to professional services that are impersonal, and things that are done. You go online and you find somebody or something, a website, and you get a one-off service, and you never talk to anybody again. Maybe you never even spoke to a person. So to your point, having that that family attorney that you can call when there's an issue, I think is probably invaluable for some people.
Yeah, I would guess so. All right. So if for somebody to have that relationship with you, what should they do?
You can always give me a call at 724-465-5826. Stop and see us in the old R&P Cole headquarters at 655 Church Street in Indiana, or go online to the website at www.westernpalawyer.com.
He is Marshall Chriswell. Thanks so much.
Thanks a lot, Todd. Take care.
You too. It is the voice of Indiana County, WCCS. WCCS.